Hello, and welcome to the lecture series for Ethics in the Legal Environment at the University of Mississippi. I'm Roun McNeal, your instructor, and we're wrapping up this course. This unit on maintaining the integrity of the profession is the last unit in the course, and this is the next to last lecture in the unit. In our most recent lecture, I talked about how maintaining the integrity and reputation of the profession serves everyone by giving the public confidence in lawyers and legal professionals. And we talked about how the maintenance of the integrity and reputation of the profession has led the bar associations to police even conduct outside the courtroom and the office. In this lecture, I want to talk about how the bar polices that conduct through the obligation to report misconduct. All legal professionals, including paralegals, have an obligation to report misconduct of other professionals. I'll quote here extensively from the Model Code of Conduct of the National Federation of Paralegal Associations. Paralegals play an essential role in the delivery of legal services to clients, and their conduct, just like that of attorneys, reflects upon their competency to hold the public trust. Honesty, integrity, and trustworthiness are personal characteristics that cannot be left at the door. How do the ethical boards learn of breaches of conduct by attorneys and paralegals? Clients, other attorneys, and court personnel can bring an ethical complaint against an attorney who has shown that he may not be fit to practice due to some action or statement. However, as the profession is self-policing, this means that it disciplines its own members. It must rely on its own members to report misconduct. End quote. Remember that the legal profession is largely a self-policing profession. Paralegals, especially paralegals who have earned a certification through a professional association, should be motivated to follow the ethical procedures. And courts have recognized protections for paralegals who do so, even in spite of the instructions of their bosses. In a Pennsylvania case in federal district court via diversity jurisdiction, the court heard a case styled paralegal versus lawyer, in which a paralegal sued her boss for wrongful discharge. She claimed she was fired because she reported to the Ethical Review Board that her boss had instructed her to backdate a letter so that he would avoid a disciplinary complaint. The lawyer in the case filed a motion for summary judgment, but the federal district court dismissed the motion because properly disclosing the unethical conduct of a person operating under a state license to serve the public is not valid grounds for employment termination. The backdating of the letter to avoid discipline was a clear indicator of fraud, deceit, and an unfitness to practice law. Persons with knowledge of misconduct by another legal professional should report it to the appropriate authorities. Remember that in this context, knowledge does not have to be an absolute certainty, but rather a near certainty of belief that a fact is most likely true. One Louisiana court said that where a law has, quote, a firm opinion that the conduct in question more likely than not occurred, end quote, and that the conduct was unethical, that lawyer has a duty to report the incident to the appropriate authorities. In other words, a lawyer has an ethical duty to tattle on his misbehaving colleagues. Why? Because when lawyers act unethically, people's lives can be disrupted, their rights can be violated, and even their liberty suspended. An exceptional case of the failure to report attorney misconduct can be found in a 2005 Louisiana case styled N. Re. Reelman. There, a former assistant district attorney named Gary Deegan learned that he was dying of colon cancer, and he confessed to his friend and former colleague Michael Reelman that he, Deegan, had suppressed exculpatory evidence in a criminal case while they were both working in the prosecutor's office. Reelman unwisely chose not to report this admitted misconduct of his friend Deegan to the Office of Disciplinary Counsel or a court. Later, after Deegan was dead, Reelman learned about a death row inmate whom Deegan had prosecuted, and Reelman became convinced that this convict was the same defendant in whose trial Deegan suppressed evidence. Reelman executed an affidavit in support of that defendant's motion to reverse his conviction. Ultimately, the Office of Disciplinary Counsel in Louisiana filed ethical charges against Reelman for violating Rule 8.3 of the Rules of Professional Conduct by failing to promptly report the misconduct of Deegan. While Reelman pointed to his poor judgment as a result of both the shock of his friend's impending death and problems in his own personal life, the court noted that his failure to promptly report his friend's ethical misconduct resulted in several more years of incarceration for an innocent man. Reelman was issued a public reprimand, which is the second least punitive action the bar can take against an attorney. Rule 8.3 requires lawyers to report conduct that raises a substantial question about a lawyer's honesty, trustworthiness, or fitness as a lawyer. The modern reading of the rule offers reporting lawyers some measure of judgment. The violation in question must raise a substantial question about honesty, trustworthiness, or fitness. And when an attorney or paralegal becomes aware of another's potential violation of rules or other action that reflects poorly upon the other's capacity to practice law, the legal professional must determine how serious the actions or inactions are and whether they impact the individual's ability to perform legal duties to the standard required. This standard seems hazy, and it is, but a few bright line rules stand out. The first bright line rule is criminal law and violations thereof. Criminal conduct is grounds to suspect that someone is unfit to practice law. The Eighth Circuit in one case opined about a lawyer who was stopped for DUI and refusing a breathalyzer and said that such conduct reflects upon one's fitness to practice law and brings the bench and bar into disrepute. Criminal convictions are self-reporting, but legal professionals have an obligation to report criminal activity which may not otherwise be known to the system. Second, dishonesty in personal affairs can reflect poorly on the professional and on the profession. Mississippi Rule of Professional Conduct 8.4 says it is professional misconduct for a lawyer to engage in conduct that involves dishonesty, fraud, deceit, or misrepresentation. Behavior that involves lying, cheating, or evasiveness rises to a reportable level. Even in personal transactions, a lawyer must maintain honest business practices. Some attorneys, for example, may have business interests that are unrelated to their law practice. Conduct in those extra-legal endeavors that calls into question a lawyer's honest, trustworthiness, or fitness is actionable by the bar. Not all unsavory character traits will implicate those qualities, and therefore not all unsavory character traits rise to the level of reportable misconduct. Some courts have said, for example, that failure to pay child support is not by itself reportable misconduct to the bar, because while it does create the impression that someone is a bad dad, it doesn't necessarily make them a bad lawyer. The key takeaway here is that the conduct of lawyers, even outside the office and courtroom, reflects upon the profession, so other lawyers have an ethical obligation to report that conduct if it raises a substantial question about the lawyer's honesty, trustworthiness, or fitness to practice law. One final note. Disclosure should be limited to only such information as is necessary to disclose the misconduct. People who disclose another lawyer's misconduct should be as limited as possible, and such disclosure is only mandated to the Ethical Review Board. Disclosing to public forums could be unnecessarily broad and subject the reporter to his own disciplinary proceedings. In our next and final lecture, we will cover Rule 8.4, which is sometimes called a catch-all rule, and that will wrap up the semester and the course. Until next time.